Okay. Why there's there? Oh my God. Who's this? Okay. Sorry about that. Okay. Um, let's start ya. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good early morning for Giovanni Chiarini, and good afternoon, dear colleagues, professors, and students, wherever you are. Now we have privilege to have our guest lecture from Giovanni Chiarini about a topic that is really extremely interested for us, about the ecocide. Me myself have encountered this issue around 10 years ago when I did my PhD study, but then it's still growing up until now. So Dr. Giovanni is now at the US, and the time is really not inconvenient. So I guess we should move forward, and then the session will be moderated by Ms. Meta. Ms. Meta, I give the screen to you. Thank you very much.
Thank you so much, Bapak Ari, for the opening speech and also the introduction. So now we are heading to the demonstrations of this event, which the public lecture given by Mr. Giovanni Chiarini from the Texas University and also Center for Military and Law and Policy, Texas. So good morning, Mr. Chiarini. How are you today? So I hope it's still have your spirit despite the inconvenient time. So we are going to talk about the ecocide that have been a long discussion since at least the employment of the orange agents in the Vietnam War. So today we are so pleased to have Mr. Giovanni to talk about the ecocide, which also been have the very long history of publications within the environmental international law. So first, I would like to give the introductions of our
Meta, you're freezing.
So an international fellow of the National Institute of Military Justice in Washington, D.C. He was previously a visiting researcher at the Center for Criminal Justice and Human Rights at the University College Cork, Ireland, Institute for the International Peace and Security Law at the Universität zu Köln, German. And there are so many long lists of his participating within the scholarships realm. So I think I will give the screens and also the place to Mr. Giovanni to give the lectures about the ecocide. He will introduce about how is the ecocide will become the jurisdictions of ICC, and also maybe about the importance of ecocide become the crimes under the international law. Mr. Giovanni, the place and the screen is yours.
Okay, so thank you very much. Very glad to be here in Texas. It's night, so I try to select some main argument that we can discuss it together. Let me share my screen so I can maybe share a presentation. Can you see the presentation?
It's clear.
Can you see the presentation? Yes. Okay.
Yes, I can see it clear.
Okay. Great. So the first title was Ecocide and Mass Environmental Destruction, so United Nations policies and the role of international criminal justice. Since here is going to the 2 in the morning, I'll try to select and focus the attention to international criminal justice and ecocide. So let's avoid, at least now, the United Nations policies, and maybe we can discuss it later if you have time. And Meta, as you mentioned before, I'd like to make an introduction of international criminal justice.
Yes.
So I'll be dividing this discussion in 4 parts, essentially. Now I recall to the basic principle of international criminal law and procedure. And then the second part is a brief account of the history of ecocide. The third part is the recent proposal of the Stop Ecocide Foundation 2021. And the fourth part, if we have time, is procedural issues that characterize both the ICC and the crime of ecocide, as well as the possible role of the United Nations policy. Then maybe we can dedicate conclusion for question and answer, but feel free to stop me whenever you want. So, yes, to fully understand the notion of international criminal justice, we should start from the history of international criminal trials. Dedicated 5-10 minutes to history. Our self is to begin from the birth of the modern international criminal procedure, which is to be found not in the Nuremberg trials, as we usually tend to believe, but in the First World War, in the aftermath of the First World War, the trial of the Kaiser, the German Emperor William II, the Treaty of Versailles, in Article 227, we are in 1990, so before the Second World War, after the First World War. This Treaty of Versailles, as Article 227, stated that a special tribunal will be constituted to try the German Emperor, consisting of 5 judges from the US, Great Britain, France, Italy, and Japan, and the military powers. But in the end, they never established that tribunal because, in short, the Kaiser fled to the Netherlands. He obtained an asylum. And this failure, this epic failure of international criminal justice, constitutes and serves as a basis for the next Nuremberg trial. You know why? Because out of the 20,000 Germans to be tried after the First World War, 20,000, only 22 were tried, and the highest sentence was only 3 years of imprisonment, which was never carried out. So it was a total disaster because they never established this special international tribunal despite the treaty, and they started the so-called Leipzig trial, which was essentially a national trial. So after the Kaiser experience, Second World War, as we all know, it's the time of Nuremberg trial. So it's a great status of Nuremberg trial, 30 articles. And Nuremberg is still very interesting, as you surely know. It was also the first experience of simultaneous translation in a criminal trial. Imagine to translate the Russian language, the French, the German, and the English was not so easy in 1946, 1947. And its evolution in 1947 is the Tokyo trial, to try the Japanese. If you're curious about the Tokyo trial, you can see a good series on Netflix called Tokyo Trials, which is a good introduction to this trial. The name, is not Nuremberg trial and Tokyo trial. It's IMT, International Military Tribunal for Nuremberg, and International Military Tribunal for the Far East. Anyway, Tokyo trial represents the evolution of Nuremberg, since the bench was composed by 11 judges, not only 4 judges, also from India, China, the Philippines. And there were several dissenting opinions were issued. If you're curious about the dissenting opinion, for example, in Tokyo trial, I invite you to read the PAL dissenting opinion, the Indian judges, which is very interesting. It's very long. It's hundreds and hundreds of pages. Anyway, Tokyo trial represents the evolution, the second evolution of international criminal procedure after Nuremberg. And then we arrive in 1991 with the United Nations tribunals, the so-called ad hoc tribunals. It's a Latin term. For the former Yugoslavia and for Rwanda. So another two different international criminal courts established by the UN Security Council. The doctrine called as tribunals with the Latin term ad hoc because they are created just for those specific territories, those specific crimes, and for an identified period of time. They are fundamental because they are based on a very well-defined procedural framework and a code of rules and procedure and evidence. And their jurisprudence is still mentioned nowadays by the ICC. And now, after the ad hoc tribunals, you see current international criminal procedure panorama, and follow, because this is an essential part to understand the weaknesses of ecocide. Now we are living a twofold experience, which is characterized on one end by the presence of a permanent international criminal court in The Hague, the ICC, created in Rome in 1998, which operated from 2002. The ICC is autonomous from the United Nations, differently from the ad hoc tribunals. It is depending from an assembly of state parties. On the other hand, there is a galaxy of little criminal courts that do not fall into any of the previous categories. These courts are characterized by the presence of international judges together with national judges and international prosecutors together with national prosecutor, but at the same time, they are influenced by the national legal system. For example, they adopt national criminal code or national rules, and they are defined hybrid courts. So hybrid because a part is international and a part is national. I'm simplifying, of course. Which ones are they? And as you see in the PowerPoint, there are several hybrid courts, which are international courts. STL, so Special Tribunal for Lebanon, KSC, Kosovo Specialist Chambers, ACCC, which is the most important. I work there, the extraordinary chambers in the course of Cambodia for the Cambodian genocide, or both genocide. The special panels for Timor East, special court for Sierra Leone, special criminal court in the Central African Republic. Anyway, so you can see the framework of international criminal justice is not so clear, right? There is, of course, a permanent international criminal court, but together with the permanent international criminal court, there are other hybrid courts. And understand this legal framework is important to understand the current discussion about the jurisdiction related to ecocide. This is international criminal procedure. So international criminal justice is composed by international criminal procedure and international criminal law, international criminal substantive law. And let me switch to the other presentation, the 4 international crimes. Also here, a short introduction. There are 4 international crimes, namely genocide, crimes against humanity, war crime, and crime of aggression. So what's genocide? Genocide? Genocide means killing members of a group, causing serious bodily or mental harm to members of a group, inflicting on a group condition of life calculated to bring about its physical destruction, imposing measures intended to prevent births within a group, forcibly transferring children of the group to another group. But be aware, because to classify this criminal act as genocide, you must demonstrate that these acts were committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. So this intent to destroy is fundamental crime of genocide. The mens rea, right? It's what characterizes genocide, and that differentiates from the crime against humanity. Crime against humanity means murder, extermination, enslavement, deportation. There is a long list. Imprisonment, torture, enforcing disappearance of person, apartheid, sexual slavery, enforced sterilization. There is a long list of crimes. But these crimes could be classified as crime against humanity only if they are committed as a part of a widespread or systematic attack against civilian population. This is the main difference between genocide and crime against humanity. And of course, not every crimes fall into the definition of crime against humanity. Murder is punished by, I think, most of the criminal code all over the world, but to constitute a crime against humanity, you have to demonstrate this mental element. Also here, I'm simplifying. Anyway, war crimes. There is a plethora of war crimes, a lengthy list. I'll give you just a few examples. Principally, they are the grave breach of the Geneva Conventions of August 1949, such as using biological weapon, attack the Red Cross, using chemical weapon, intentionally attacks objects which are not military objectives, bombarding civilians, buildings dedicated to religion, education, art, science, or charitable purpose, historical monument, hospitals. There is a long list of war crimes, Article 8 of the Rome Statute. You can find it easily. And then the crime of aggression, introduced in the Campbell Amendment after the creation of the Rome Statute, Article 8 bis, is essentially the evolution of the crime against peace forged in Nuremberg Charter of 1945. Now it's called crime of aggression. It means essentially the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state. We see nowadays the ongoing Russian-Ukraine conflict, prosecuting the crime of aggression is not so easy for several reasons. And in that case, for example, neither Ukraine nor Russia are member state of the International Criminal Courts. The jurisdiction for war crime, crime against humanity, and genocide can be activated due to Article 12, Paragraph 3 of the Rome Statute, because Ukraine accepted the declaration of jurisdiction, of acceptance of jurisdiction in 2014, as far as I remember, but there is no jurisdiction over the crime of aggression. Anyway, it's a complicated issue, and we will not talk about it today. So what about the fifth international crime? So in addition to these four crimes, a fifth international crime emerged, and the amendment to the Rome Statute has been put forward to introduce this new crime, namely ecocide. So ecocide is analogy, derived from a Greek word, oikos, which means house, home, and the Latin cedere, which means to destroy, to kill. So to destroy our house, to destroy our home, the environment. And of course, this analogies follows the word genocide, created by Raphael Lemkin, Polish jurist in 1945. So ecocide, in short, is the willful of massive destruction of the environment. And after we could also discuss the definition of the environment, which is potentially broader. But let's start with the history of ecocide. Because contrary to what we generally tend to believe, ecocide history is not so recent. Not at all. Indeed, the birth of ecocide is to be found between 1969 and 1972. So these 3 years are really important for the affirmation of ecocide. So 50 years ago, that's why I called ecocide and science, because there is no law here, either international law and criminal law. And the creation of the term ecocide, again, taking its cue from the UN Genocide Convention, is attributable to a doctor, not to a jurist, namely Dr. Arthur Galston. Galston was an American botanist and director of the Division of Biological Science in Yale. So the breakthrough of ecocide was not juridical, but scientific, related to environmental science more than law. Galston described the appealing effects of the defoliant, so-called Agent Orange, a chemical herbicide used during the Vietnam War by American troops, released to destroy crops and expose the Viet Cong positions and routes of movement in the vast forests of both Vietnam and Cambodia, so the former Indochina. They released million gallons of this chemical herbicide, together with other chemicals. A lot of chemicals were used with different color on the barrel, and they were defined as rainbow chemicals. So Agent Orange was the most dangerous since it contains high percentage of dioxin, so carcinogen and causes cancer, and teratogen causes birth defects. Anyway, the government of Vietnam says that up to 4 million people in Vietnam were exposed to this defoliant, and as many as 3 million people have suffered illness because of Agent Orange. Also, some American soldiers suffer illness due to Agent Orange. People were disabled or have health problems as a result of this exposure. And I also included some, you see, some photos of the usage of chemicals they called rainbow herbicide, you see. So Agent Green, Agent Pink, Agent Purple, Agent Blue, Agent White, Agent Orange. Every agent with different aims. So defoliation of jungle vegetation, crop destruction. Anyway, most of them were used to destroy vegetation. You see another here. You see, this is US Armed Forces. So spraying Agent Orange, defoliant in South Vietnam. And this is a aerial photograph showing the effects of Agent Orange. As you can see, the land on the left hasn't been sprayed, while the land on the right has. So you can see the difference in the destruction of the vegetation of the environment. Here there is some still protest ongoing in Vietnam about Agent Orange. You see, by Vietnamese students representing disabled child victims of the defoliant Agent Orange. They are still disabled child victims, according to the Vietnam government. So Dr. Galston observed that the warfare use of these chemicals was eliminating one of the most important ecological life cycles. And he proposed a tripartition of the ecocide damage still pertinent. For Galston, ecocide has a triple effect. One is the ecological damage, the second will be the agricultural damage, and the third involves direct damage to the people. So they're all interconnected. And he also noted actually that the first usage of Agent Orange was by the British Army during the Malayan emergency, so in the early 1950s. And the Galston revelations regarding the Vietnam War led the former US president, I think it was Richard Nixon at that time, to order a halt to its use. So after the Galston accusation, the US Army stopped the chemical aggression in Vietnam, at least of the Agent Orange. And 1 year later, in 1917, stay here, during the Conference on War and National Responsibility in Washington, he proposed a plea to ban ecocide. His pioneering view, we could say, still constitute the affirmation of ecocide. And in the following years, several scholars dedicated their studies to this field, including jurists. And moreover, still it's important too, a part of the political community was drawn to the issue. It's very important, the UN Stockholm Conference on the Human Environment, with the lead role of Prime Minister Swedish Olof Palme in 1972, which is considered the birth of the green generation. Anyway, let's now go to discuss some law. This is the first juridical proposal related to ecocide. So the first juridical proposal is not to be found 2 years ago or 1 year ago. It's the Stop Ecocide Foundation, but in the Richard Falk proposal. Professor Falk still started from the environmental warfare in the China, so in Vietnam, proposed an international convention, including a very precise juridical definition and a long list of criminal conducts. For Falk, ecocide means any act committed with the intent to disrupt or destroy, in whole or in part, a human ecosystem. So it reminds me every time the formulation of genocide, right? Genocide is an act committed with the intent to destroy, in whole or in part, a national, ethnic, or racial or religious group. So it's very similar, core, and clear. And we are in 1970, right? Falk proposed a list of several possibilities, such as the use of weapons of mass destruction, as you can read, whether nuclear, bacteriological, chemical, herbicides to defoliate and deforest natural forests for military purposes. So it's referring to Vietnam. The forcible removal of human beings or animals from their habitual places. And along this that you can easily find the Richard Falk proposal. I can forward it to you later, where you are to meet. Some students are interested in reading the original Richard Falk proposal. I divided the Falk proposal in two parts also here. So one of substantive law and one about procedural issues. The main pillars of the substantive law are Articles 3 and 4 of the Falk proposal, namely the possibility to punish the conspiracy to commit ecocide, the public incitement to ecocide, the attempt, the complicity, and in addition, he stated that the constitutional responsible rulers, public officers, military commanders, as well as private individuals, may all be charged and convicted of the crime associated with ecocide. And similarly, Article 4 of its proposal provides that who committed ecocide shall be punished at least to the extent of being removed for a period of years from any position of leadership or public trust. You can see in the substantive law part. And regarding the procedural structure, this is much more interesting. He proposed, Article 5, a special commission for the investigation of ecocide. This is really interesting. Composed of 15 experts on international law, assisted by a staff conversant with ecology. And this was a great idea, in my opinion, that we cannot find in the recent proposal, and that constitutes the first interconnection between environmental science and international criminal law. Moreover, he highlighted that ecocide shall not be considered as political crimes for the purpose of extradition. Therefore, he obligated the states to pledge themselves in such cases to grant extradition, and he wisely left the door open to a double jurisdiction in both Articles 7 and 10. So he proposed, on one hand, the establishment of an international competent tribunal, so a new international tribunal. The juridical nature of this tribunal, probably, it's similar to the hybrid courts that we see in introduction. And on the other hand, he proposed the establishment of a criminal chamber within the International Court of Justice in The Hague, because we are in 1973, so without a permanent International Criminal Court. There was not an International Criminal Court, and the idea of establishing an international permanent criminal court was not so discussed. So his proposal was revolutionary. As we know, unfortunately, this proposal was never approved, but this is the juridical genesis of the crime of ecocide. What's the limit of this FAG's draft? This is essentially one. Its proposal was strictly related to a concept of ecocide as a war crime, only as a war crime, not as a crime against humanity. And then let's go still in the history of ecocide. This part, I'm trying to shorten it a bit, is not very interesting for lawyers, but it's important because it's the political part of ecocide history. You see, from 1978 to 1998, there were a lot of debates about how to classify the crime of ecocide, how to define the crime of ecocide. And they talk more about environmental crimes than crime of ecocide, okay? They talk more about environmental crimes in general. You can read the reports of the UN Special Rapporteur, especially Nikodem Lukashenko and Benjamin Whitaker, which is interesting, the discussion about cultural genocide, ethnocide, and ecocide. But anyway, both proposals were not developed more by the subcommission. So let's go ahead. This is, on the contrary, we have to dedicate some minutes about the ILC draft. So you see, from 1986, 1996, the International Law Commission, you know, the International Law Commission is a creation of the United Nations. By virtue of General Assembly Resolution 1948, was created as a subsidiary organ with the aim to support the Sixth Committee, namely the Legal Committee, and to develop international law and this codification starting from the Northern Principles. So anyway, the ILC, International Commission, the mission, one of the main missions of the International Law Commission was to draft the so-called Code of Crime Against Peace and the Security of Mankind. And there was years of debate to classify in Article 26 of this code the serious damage to the environment and the prohibition of the massive pollution of the atmosphere or the seas as crime against humanity. So this was a one step forward. Because if you can classify as crime against humanity any serious damage to the environment and the prohibition of the massive pollution of the atmosphere of the seas, essentially is ecocide. I'm simplifying, but there was a first proposal, right, to introduce ecocide, despite its definition, its name. And more important, ecocide was discussed as a crime against humanity and not as a mere war crime, so another step further. And then the problem is that Article 26 disappeared after a long discussions. It was never approved. It was removed completely and somehow first say somewhat mysteriously from the code. So you see a lot of discussions throughout the years, but nothing concrete in the end. And now we arrive at the Rome Statute of the International Criminal Court. This is another step back. This is another step back. There is no trace of Article 26, and the damage to the environment return as a mere war crime. A few years later, in the Rome Statute, namely the Organic Charter of International Criminal Court, Article 8, paragraph B, Article 8, paragraph 2, letter B, number 4 of the ICC Rome Statute provides that war crimes also means long-term and severe damage to the natural environment, which will be clearly excessive in relation to the concrete and direct overall military advantage anticipated. So the norm is limited to armed conflict, still considered as a war crime. And this is the problem of the FAG proposal, limited to the war crimes. The difference is the FAG proposal is dated in 1973, and Article 8 is dated in 1998. Moreover, regarding criminal law issue, if you can read the norm, you can check that the actus reus must be widespread, severe, and causing long-term environmental damage. The actus reus cannot have been committed as a part of concrete military advantage, and the mens rea must be intentional. So this Article 8 demands a very high threshold of injury to the environment before an act will be and would fall within the scope of the crime. And the use of the conjunctive and between the words widespread, long-term, and severe, rather than the disjunctive form, is a regression from the standard that had been specified in the Convention on the Prohibition of Military Hostile Use of Environmental Modification Techniques. Because you see, if we use the conjunction form and, automatically means that all the requirements shall be proved to classify Article 8 as a war crime. So this norm is characterized by this triple and cumulative standard of widespread, long-term, and severe that must be met before environmental damage is prohibited, thus very difficult to demonstrate for a prosecutor. Anyway, Article 8 of the Rome Statute, I want to spend some good words for it, is the first ecocentric crime recognized by the international community. So we could say its introduction into the ICC statute was a kind of two-step forward because it was the first ecocentric crime, and one step back, since the classification as a mere war crime is still not enough for both exigent of prevention and protection of the environment and prosecution of those criminals too. Furthermore, environmental damage takes place primarily during time of peace, primarily. And so there is the necessity to go beyond the military conflict. So this was the history in short of ecocide. And now we are going, watch how many more minutes, checking the time. We are going to the third part of this presentation, namely the recent amendments proposed by the Stop Ecocide Foundation last summer. So the Stop Ecocide Foundation, you probably heard about it, is a recent association established in the UK a few years ago. They selected 12 eminent lawyers, including Philip Sand, with a balance of backgrounds and expertise in criminal, environmental, and climate law, essentially. And they proposed the addition of Article 8 there into the Rome Statute, namely ecocide. But following their draft, ecocide means literally unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Environment, they propose also definition of environment, which means the earth, the biosphere, cryosphere, lithosphere, hydrosphere, atmosphere, outer space. And let's look at the main requirements of the norm. Wanton, severe, widespread, long-term. Wanton means reckless disregard, international law, essentially. Severe means a damage which involves in disruption to any element of the environment. And they included also grave impacts on human life or natural, cultural, and economic resources. Widespread means, and this is the most interesting part, in my opinion, a damage which extends beyond a limited geographic area, crosses state boundaries, or is suffered by an entire ecosystem of species or a large number of human beings. So, damage which extend beyond a limited geographic area, okay, crosses state boundaries, suffered by an entire ecosystem of species. Imagine a nuclear disaster, for example. And still imagine a nuclear disaster regarding long-term damage. What does it mean, long-term damage? A damage which is irreversible, or which cannot be redressed through natural recovery within a reasonable period of time. So they created a very simple and clear concept of ecocide, which is remarkable. But what about the procedure? And now I'm going to highlight, and I'm going to the end of the presentation, just under 15 minutes. I'm going to highlight some of the main procedural issues that characterize the proposal, but they are implicitly in the International Criminal Court. So this proposal usually take 3 guest lectures to be explained. Is the proposal I wrote, and together with our center, UCC, University College Cork, we put forward additional amendment to the Stop Ecocide proposal. And it is divided in 7 macro categories, namely jurisdiction, ratione temporis, and the problem of withdrawal, deferral investigation and prosecution, the introduction of aggravated ecocide in relation to climate change, the exercise of jurisdiction on the basis of the UN environmental authorities, a change in the standard of proof, a presumption of issues of the admissibility of gravity and interest of justice, and some amendment related to the proceeding on admission of guilt. It's very complicated. It's a very long proposal. So I just sum up some of the main parts. And I recall you to another basic principle of international crime proceeding. You can see I inserted some part of the proposal, but I don't want to read that. I prefer to explain you and sum up the main macro categories. So I stay here. Regarding the jurisdiction, for example, I select the main part. You know, the ICC jurisdiction in respect to the basic principle of criminal procedure has 4 different phases. Jurisdiction, ratione materia, subject matter jurisdiction, jurisdiction, ratione persone, jurisdiction of a person, jurisdiction, ratione loci, talking Latin, territorial jurisdiction, and jurisdiction, ratione temporis, temporal jurisdiction. So jurisdiction, subject matter jurisdiction means essentially the 4 international crimes and the 5th international crime of ecocide would be inserted. Jurisdiction over person means that the ICC has jurisdiction over citizens of state parties, both victims and defendants. Territorial jurisdiction means that the ICC has jurisdiction over territories of a member state, despite the citizenship, or on a non-member state, if they activated the special procedure of Article 12, Paragraph 3, as Ukraine did in 2014. Declaration of acceptance of jurisdiction lodged by a non-state party. And then temporal jurisdiction, essentially the respect to the non-retroactivity principle. So all the crime of ecocide occurred before the introduction of the amendment cannot be prosecuted by the ICC. Okay, only after the amendment, of course. Regarding the jurisdiction, ratione temporis, one of the macro amendments proposed is to change Article 127 of the Rome Statute. We are going into the complicated issue. This article provides the possibility for a state party to withdraw from the ICC by a written notification addressed to the UN Secretary General. There are 2 cases of withdrawal in the history of the ICC. One is Uganda and one is the Philippines, very recent, after the so-called war on drugs launched by the President Duterte. The ICC started a preliminary examination, then the Philippine government resigned from that withdrawal. This withdrawal, according to Article 127, take effect 1 year after the date of receipt of the notification. So I believe that this 1 year limit is not suitable for the crime of ecocide. Why? Considering the implicitly long-term damage of ecocide. Imagine some state parties involved or a complicity, the crime of ecocide, you can decide to withdraw, and the withdrawal will take effect after 1 year. So maybe you discover, you prosecutor, you discover the long-term effect of ecocide after 5 or 6 years. So I don't think this 1 year limit is suitable for crime of ecocide. The crime of ecocide necessitate of a different and well-defined procedure, a special procedure dedicated to ecocide. Other amendments involve the deferral of investigation or prosecution, and this is a proposal to reduce the power of the UN Security Council contained in Article 16 of the Rome Statute, but we don't have time to go in depth into this issue. The other important amendment is the introduction of aggravated ecocide, and the aggravated circumstance of substantial impact on greenhouse gas emission or climate change. This is probably the most important part of the proposal, since we put forward a definition of aggravated ecocide in recognition of the long-lasting and cross-border harms. And also, this has an impact about the sentencing criteria of the ICC Rome Statute and rule of procedure and evidence. In the International Criminal Court, the range of the sentence is predetermined by the statutory law, Article 77, as far as I remember, for the trial phase, and 110 for the appeal. And the ICC may impose imprisonment for a specified number of years, which may not exceed a maximum of 30 years. But the term of life imprisonment is justified by the extreme gravity of the crime or aggravating circumstances, and the special individual circumstances of the convicted person. So introducing aggravating circumstance about ecocide in case of impact on greenhouse gas and climate change can allow judges to issue a sentence of life imprisonment. Other important amendment relates with the exercise of jurisdiction on the basis of a UN environmental authorities reports. And this reminds me, and I inspired this amendment to the FACT's proposal, to the idea of FACT to introduce a special commission, remember, of jurists with the staff of conversant with ecology. Why? Because determining the commission of the crime of ecocide is primarily a task of the science. So I will propose a special exercise of jurisdiction based on UN environmental authorities reports, such as the reports of the IPCC, the Panel on Climate Change, the Special Rapporteur on the promotion and protection of human rights in the context of climate change, and the Special Rapporteurs on human rights and environment. If you have time, or if you're interested in this subject matter, I suggest you to read the report of the IPCC, the Panel on Climate Change. Is the UN body for assessing the science related to climate change. It's a very long report, but it's very interesting to understand the importance and the gravity of climate change nowadays. And procedurally speaking, this part of the proposal is to confer a procedural privilege value to the scientific reports. So creating an interconnection between environmental science and law and changing the standard of proof in case the information on crime related to ecocide are coming from these environmental authorities. Okay. So this is in short, and I try to sum up the proposal. I know I cut, half of the presentation, but maybe we have time next year to do another presentation on that. Just another important things, some students are not familiar with international criminal procedure. When you're reading a proposal in an ongoing case about the preliminary examination, remember, preliminary examination is not an investigation in the ICC legal framework. There are very different phases. The preliminary examination may be initiated by the Office of the Prosecutor, taking into account the information received by groups, individuals, by referral of state parties to the Security Council, or in the case of EcoSite, regarding this amendment by the UN environmental authorities. Anyway, the preliminary examination is essentially a phase of evaluation of the information received. It's a screening, it's a full-phase filter process, quite complicated, where issues of admissibility and jurisdiction are analyzed. And then after all the requirements are satisfied, the prosecutor can ask the green light, start an investigation to the predatory chamber. Anyway, this is a very important distinction. There is still some confusion about that from the non-jurists especially. I will conclude, and if someone has some question and answer, just this is the proposal that I wanted to discuss. It's quite complete. This is all the amendments selected for this presentation. And this is the conclusion, essentially. So thank you for having me, and feel free to ask me any question you may have.
Yeah, well, thank you, Mr. Chiarini, for the presentations and about the explanations about the EcoSet. So what I can conclude from the presentation is that the EcoSet is actually been long discussions for the scholars or even prosecutors within the topic of international criminal law. Somehow the damage or the criminal actions toward the environment is only limited to the war crimes. However, the damage to the environment is not real. It's also happening, it's even in the peacetime. And therefore, that the difficulty is how to address the responsibility over individual or even the state, if I can also adding to some questions about the act of the EcoSet itself. Therefore, from your presentations is also I can conclude that there are some difficulty in terms of jurisdiction matters within the ICC itself, because the ICC it also seems to adopt the same manners like the previous tribunal with regard to the damage of environments, which is also include the environmental damage to be the act of the war crimes. So it is a very interesting issues and also interesting discussions. So I will allow the participant in this room to have a questions, and please raise your hands, and our committee will unmute you to have direct questions toward the speakers. Okay, Bapak Rizky, maybe you can have direct interactions with the speakers. Maybe you can unmute yourself and also turn on your camera.
This is a very long question.
Yeah, indeed.
Okay. Excuse me, Mr. Chiarini, thank you for your time to enlighten us more about the EcoSite. I'd like to ask you a number of questions in regards to the EcoSite that we discussed today, if you don't mind. The first question is about, considering the state of our environment and the fact that some of the nature are diminishing at such a rapid pace, what's your opinion about the law in regards to preserving the environment? Wasn't taken seriously in some countries like ours, as evidenced with the number of destruction committed by both individuals and corporations increasing each time. And the second question, given the fact that law regarding EcoSite is greatly needed in order to keep our environment intact, as well as to recover the world and to punish those who are responsible for such act, why is EcoSite not already the part of the greater law, such as Rome Statute, for example, since EcoSite was included in the draft before being removed at a later stage of the Rome Statute, if I remember correctly. And the final question is, if the law about EcoSite was later recognized fully as an international law, that would mean that it affected anyone globally, both individuals and corporations. If such things were to affect business, wouldn't that also mean that it affected people's or laborers' livelihoods in a negative way economically in exchange of preserving our nature? Thank you in advance for your time. That's pretty much it.
Okay, well, thank you, Bapak Rizky. It's a very long question and also important question, I think, because it's addressing how the international law or the state can be responsible to individual, because with regard to the law, if not taken seriously, whether or not it can be considered that the state is unwilling and also unable to handle that such of cases. Maybe Mr. Giovanni, you can answer that question.
Yeah, I try to answer that question not in a disorder. He put forward 3 very important questions. Probably there are more than 3 questions inside. So I just reply in general. Let me check. Was the first one? It was okay. So, okay, some countries and okay. So first, in general, remember that International Criminal Court, despite its international character, is not a global court.
Mm.
International criminal justice is not global justice for an essential reason. The state parties of the International Criminal Court are 125, now 123 after the withdrawal of the Philippines and Uganda. And the US are not a state party of the ICC. Russia is not a state party. China is not a state party. India is not a state party. Most of the Arabic countries are not state parties. So this, you have already a lack of jurisdiction over most powerful countries. Okay. So this is one of the main characters of the ICC. It's established by a treaty, and some states didn't enjoy the ICC. Another answer to your question about the corporation, I agree with your observation, but the ICC, differently from Nuremberg and Tokyo trials, lacks jurisdiction over corporate entities and can therefore only prosecute individual corporate officers, thus failing to attribute criminal accountability to the corporation as a collective entity. This is another limit of the ICC. Another limit of the ICC is that, procedurally speaking, remember that the ICC does not try individuals unless they are present in the courtroom. Article 63, trial in absentia. So imagine a corporate officer accused by ecocide that should go there to the ICC. Otherwise, the trial cannot start. I'm still simplifying, but these 3 characters are for sure affect the way of prosecuting concretely ecocide through the International Criminal Court. And that's why, still regarding your question, let me check. In the third, okay, if the law about ecocide was later recognized fully as an international law, that would mean that it affected anyone globally. Yeah, but as I say, the ICC, International Criminal Court, is not a global court. And that's why another interesting discussion about ecocide and how to prosecute ecocide globally is prosecuting ecocide through the so-called universal jurisdiction. You know, universal jurisdiction. We should dedicate some lecture on universal jurisdiction, but in short, is a principle that allows state to prosecute international crime, even though they are not state member of the ICC. The first historical case was the Eichmann trials, where the Israelis brought Eichmann to Israel for the crime committed in the Second World War. So prosecuting ecocide through universal jurisdiction is another great discussion. I mean, we can discuss about your question for hours. You could feel free to contact me by email or I can send you some materials if I see you're interested in the topic. So, and also remember to introduce ecocide in the Rome Statute is not so easy. There is the process to amend the Rome Statute is not so easy. You need 2/4 of the majority or 7/8 of the majority, and the state can withdraw with immediate effect in case the majority has not been reached. So it's quite complicated issue. There is another questions, I think.
Yeah, there are other questions from Ibu Dea Nuraini, which he asked about which international treaty is best to describe crimes against humanity. Maybe in addition to that, whether or not, since there are no kind of element of crime, including ecocide as one of the international crime, whether the ecocide itself can be included in one of the element crimes against humanity, maybe perhaps in the elements of others in human acts, perhaps, because we can propose that the damage to the environment as an act of an attack to the civilians. Maybe for the additions to that questions, Sir Chiarini.
Yeah, I also see another question. What's the difference between war crime, crime against humanity? So essentially, to classify ecocide as a war crime or crime against humanity is not only a problem of definition. It's changed a lot. First, war crimes means a crime committed during a war or an armed conflict. Crime against humanity, no. Not this limit of crime against humanity. Moreover, the current discussion is to introduce ecocide as a fifth autonomous crime.
Okay.
So with neither juridical nature of crime against humanity nor war crimes. I think this will be the best way also to avoid misinterpretation about the classification of ecocide as a crime against humanity. Anyway, if I have to choose to ecocide as a war crime or ecocide as a crime against humanity, I will choose ecocide as a crime against humanity. The difference is essentially, there are a lot of differences. Don't misunderstand me, but the difference is essentially one is committed during an armed conflict, one both during armed conflict or peace. Okay. And then if you commit, there is several requirements. For example, some war crimes are not war crimes if they are committed as a part of a military advantage. So this is another great issue about more international human rights law than international criminal procedure. But yes, anyway, your question more than legit. Yeah, which international treaty best describe crime against humanity? Also here, I suggest you start easily, just read the Rome Statute of the crime against humanity, and you can understand at least 90% of the discipline of crime against humanity. If you want to go in depth into international criminal law, international crime, I suggest this book written by Antonio Cassese, which is one of the greatest scholars in international criminal law. It's Oxford University Press. Another author that I suggest you is Sheriff Bassiouni, which is one of the other greatest scholars in international criminal law. They are both passed away, but they were the father of international criminal law. Also another books. This is a non-juridical books. You can read it in the train or in the flight or whenever you have free time. It's Philip Sand, East, West, Street. I'm not promoting their books. I'm just suggesting some worth reading. East, West Street by Philip Sand can help you to understand the difference between war crime and crime against humanity in a very easy way and a very pleasant way of reading. I would suggest other books. There's one by Matthew Gillett, I think. I don't remember the exact title, but it's about environmental crimes and it is edited by Cambridge University Press. And he mentioned me, I think, 30 times of his monograph, so it's quite interesting for me. But anyway, it's a good collection of environmental crime, environmental arms in international criminal law. Now, some scholars are talking more about animals in international criminal law, the damage to animals in international criminal law, which is quite interesting, but in my opinion, it still falls into the crime of ecocide. Because if you are now talking about introducing a sixth crime against animals in the International Criminal Court, probably we will discuss another 20, 30, 40 years without introducing nothing. So I will focus the attention to ecocide. Anyway, if you have any other question that bear in your mind, just feel free to contact me in my personal email or LinkedIn or my email of Texas Tech. I send you some reference and you can find me and ask me everything. Also, I propose to give a look, if you're interested in International Criminal Court, to the possibility to make an internship in International Criminal Court. This is the first step to be admitted in International Criminal Law career. I started with an internship 3 years ago in the ACCC, so the Extraordinary Chambers in the Court of Cambodia, and then being admitted in the list of lawyers in International Criminal Court, and now consultant in other tribunals. Anyway, I don't know if you have any other question. I can also forward to you some papers of mine about ecocide, so you can read the proposal if you're interested.
Okay, I think I see that another question arises from Ibu Nabila Putri. If maybe Ibu Nabila, you can ask the question directly to the speakers. Maybe it is the last question for the sessions, because we have to limit our time due to the inconvenient time in your part, Mr. But thank you so much for your presentations anyway. Yeah. Ibu Nabila Putri, do you have any questions? Ibu Nabila? Okay. We have another questions from Bapak Yudi Yuda. So he asks whether crimes against humanity have recently occurred in this world, for example, war.
This is a tough question. Probably we should ask this question to politicians and, weapons industry. I don't know why war is still used as an instrument of dispute solution. For sure, the failure of diplomacy and the failure of probably international agreement between states that bound states to ban war. But anyway, I don't think there is an answer to that question throughout the history. I would like to have an answer, but I'm honest, I don't, especially in light of the recent ongoing conflicts in 2022. And nowadays, what makes me worried is the presence of a lot of nuclear weapons and nuclear stations, which is an additional element of dangerousness during a time of war. Is there any possibility that you can classify as one international crime already in statute? The Assembly of the State Parties of the International Criminal Court will take place this December, and they think the possibility to introduce crime of ecocide will be discussed. let's see. Let's update each other after the second weeks of December. It takes place from the 1st of December until the 14th of December, as far as I remember. So let's see. I don't think they will introduce the crime of ecocide now. Probably it takes another couple of years. And I think I'm positive, but let's see. Let's see. Thank you so much, of course. Okay, so thank you very much. And I think I'm running to the bed because it's almost 3 in the night here. And so anyway, yeah, nice to meet you. Nice to meet you, University. I hope to meeting you in presence soon and to visit the beautiful country.
Yeah, thank you so much. Thank you so much, sir, for the presentation. And also, I would like to thank you for all participants. And also, I see that the Vice Dean of the faculty is also joining us to the presentations. I would like to say hello also, but I think this is the end of the time for these sessions. Thank you so much. I hope we can have another sessions to talk about and elaborate more about the ecocide itself. So I think we should have another one session of taking a photo if you
yeah, all right.
Yeah, so maybe maybe the host of the Zoom can help to take the photo. Okay, maybe all the participants, you can turn on your camera. So I have 4 pages here. So 1, 2, 3, smile. Second page, 1, 2, 3. Third page, 1, 2, 3. And the fourth page, 1, 2, 3. Okay, thank you so much for your attendance to the event. Thank you so much again for Sirs Giovanni and also Pa Andre Wibisana, and also yeah, Pa Ari also say thank you for you to come. So this is the end. I'd like to end these sessions. Assalamualaikum warahmatullahi. Have a good night and also have a good pleasant evening.
Thank you very much again. Nice to meet you.